Doyle, another member of Michael Green's list, and I'm here to talk about bail. I've written a paper. If you haven't got a copy, it's outside on the table there with the other materials. I've called it Bail Some Manoeuvres, and what I've tried to focus on are submissions, techniques, and only a few cases which I found helpful in getting bail. Now, the paper's written completely from the point of view of an accused applying for bail, and I notice some of our good friends from the Office of Public Prosecutions here, so I'll try to intersperse throughout the oral presentation some observations from the prosecution's point of view. Now, firstly, you're often called upon to make bail applications at very short notice. Now, the first rule of advocacy that we're all taught is preparation, preparation, preparation. So with no genuine opportunity to prepare, that rule is of limited use. But you can still put it to some use, because there is, when you rush up to court, often a bit of pressure to get on and start running the bail application. Now, none of this pressure is put on you inappropriately by either the court or the prosecution, but usually you're the last one who's ready. So the first thing I've found is it's important just to forget about all that. You're not deliberately wasting anyone's time, but if the prosecution who's ready and the informant who's ready and the court which is ready has to wait for you to firstly read through all the materials, secondly take full instructions, thirdly wait for family members to get to court, then so be it. And it's sometimes helpful just to give some consideration to what needs to be put in place before you're ready to proceed, whether that's taking instructions, an interview with KISP or the Credit Bail Program, getting a family member to court, and letting the court know a realistic time that will give yourself enough time to do all those things to take the pressure off. Could we ask for an indulgence not before 2:15, Your Honour? And if that sort of thing is granted, then you might be giving yourself the best opportunity. Because often pressure itself is a barrier to thinking clearly and getting bail in an otherwise difficult case. Now, I found it's helpful also, given that these things do often happen at short notice, just to have a small collection of materials handy, a bail folder. This is what my bail folder looks like. It's not that thick, because in my view you don't need much by way of law, and I tend to resort to the same old cases all the time. So it's just got in it a copy of the Act and about 3 or 4 cases with copies of each. Now, I've referred to my favourite cases in the paper, and I do want to talk a bit about those, because in my experience they've pretty much got everything you need in them, even for difficult cases, or particularly for difficult cases, because the case law is perhaps not as relevant or useful in the more obvious cases in favour of a grant of bail. Now, I've put there on the second page of the paper a checklist of things to consider when you first get the materials. Obviously, you've got to look at what your client's charged with, consider what category the charge falls into. Is it a situation where you have to show cause or show exceptional circumstances? And all these things, by the way, might inform what's perhaps the most difficult decision of all, and that's whether to apply for bail on the day. And that's something I haven't gone into in the paper. It's a very difficult call often, and a judgment call you've got to make on the day, having regard to ultimately what your client wants to do. But there are some situations, particularly with heroin addicts who are obviously still withdrawing, often they will say anything to try and get out of there for understandable reasons. And ultimately, of course, it is up to them. But in circumstances where it's not in their interests to run a represented bail application, you do sometimes have to be quite firm in explaining to them the disadvantages of proceeding at this point in time. Because in cases like that, if KISP can't see them, for example, and their prior history shows that they've clearly got a drug addiction and will steal constantly to fulfil it, and there are no supports in place, the reality is most magistrates simply won't give them bail, and they're better off either not applying today or applying unrepresented, especially as not all magistrates would agree that the availability of support on the KISS program would constitute a new fact or circumstance. So the question, I suppose, to ask yourself in those situations is, would it improve our chances significantly to wait and put other things in place, whether that's getting family members to court, finding accommodation obviously is a big one, or getting the support of the KISS program. Now, reading through your client's prior convictions, there are quite a few things to consider. The nature of the prior history. If they're charged with violent offending for the first time, for example, you should check that that kind of offending hasn't come up in the past. It might not be necessarily a barrier to bail just to have a long list of priors. It might just depend on the nature of the matters, what were their circumstances at the time. And the comments in that right-hand column of a LEAP report will often give you a very good idea of the client's history of treatment and how they've gone on community-based dispositions and the like. So, in short, get your client's instructions in detail, not just on the allegations in the remand summary, but on their prior history. If they've breached CBOs in the past, find out why. Because every now and then you get a very useful and plausible explanation for why it is they breached it, and it can take the sting out of that when it comes to court. Obviously, the prosecution may allege they're not going to comply with bail conditions because in the past they've breached 3 CBOs. Now, that might be a very powerful submission, unless, of course, your client's actually got good reasons for having done that. And if you found out about them in advance, that's obviously very advantageous. Now, I'll go through the rest of the matters I raise in the paper by reference to my 3 favourite cases. These are the cases of DPP and Coetzee, a decision of Justice Couldry, in my view a great criminal judge, from 2005. Unreported decision of DPP and Bernath, Justice Williams, unreported 2003, and last year's decision of a bail application by Kyle McGee, as decided by Justice Jack Forrest in the Supreme Court. Now, I always bring these with me, not because I cite them in most bail applications, I don't, but you don't know who you're going to appear before. These cases, in my view, contain almost all of the relevant principles behind bail, and if you're dealing with an inexperienced magistrate, you might well want to quote from them, but even with experienced magistrates, they might want to test some of your submissions, and if you're pressed for authority, usually you'll find support for what you're putting in these cases. So they're a bit of a security blanket as well. I've also formed the view that we're perhaps a bit too shy of reminding magistrates of the basics. They do many of these cases, but even experienced magistrates who might huff and puff and show some displeasure and indicate that they're feeling patronised do get influenced by reciting the basic principles. And if I could put it this way, doing that, in my view, interrupts or short-circuits some modes of reasoning which can count against a grant of bail. Now, I'll give you some examples of what I'm talking about. One mode of reasoning, which is illegitimate and wouldn't be publicly announced, would be this. This is an exceptionally strong Crown case. Your client's going to do a stretch for a very serious charge. Why would we bother granting bail? He's not serving any time. He's not ultimately going to have to serve. Now, the magistrate won't put that to you, but they're all human, and we all know that the underlying reasons for a decision are not necessarily what are publicly announced, and that applies to all courts at all times. Now, if you think that there's a danger of that mode of reasoning, it can be helpful to quote from the cases. Now, this is a quote from Cotsey's case, which is set out in the paper in more fulsome form. I'll read the whole thing because it deals with delay as well as being useful where there's a strong Crown case. The concept of delay has been dealt with in many cases. It is a matter of some sensitivity where the person incarcerated has the benefit of the presumption of innocence. And it must be steadily borne in mind that bail is not about punishment in advance of a jury trial, but is designed to secure attendance at that trial. So even in the face of a strong Crown case and your client facing what might inevitably be significant punishment, that's a matter for down the track. It is not a matter for consideration of a bail application. A bail application, in the words of Justice Coldry, is about securing attendance at trial. Now, that's a very convenient quote from the defence because it also excludes other relevant considerations to bail, and this is where the prosecution have a reply to this kind of invocation of case law. Bail is also about protecting the community from someone who might reoffend in between arrest and trial. But Justice Coldry doesn't mention that in that quote. That's why it's a useful quote from the defence's point of view, because it focuses attention on one narrow factor, namely whether they will attend. And most often, there's no problem with attending, and if there is, any concern about that can be met with appropriate conditions. I've never lost a bail application on the grounds that someone's a flight risk. There are very few people who genuinely are. So, reminding a magistrate of that fundamental principle, I think can be useful in interrupting the kind of thought process that would result in the denial of bail. Similarly, if you're invoking delay. Now, delay seems to have emerged as perhaps the most significant factor in bail applications, at least in serious cases in recent years. And the authorities have very conveniently summarised in the case of Bernath, and this is a fairly short case, but it's useful for a couple of reasons. Firstly, the delay, which was calculated by the magistrate, not on any evidence, but based on his Honour's own experience, was in the vicinity of 2 years. And that is the only circumstance, it seems, His Honour relied upon to find that Mr Bernath had established exceptional circumstances in a case where he was charged with trafficking a commercial quantity of amphetamine. Now, helpfully, Justice Williams sets out how His Honour arrived at that calculation. And I've got in the paper some tips about how to generate evidence, if you like. It's not really evidence, but how to generate a good estimate of delay that you can properly put to the court, because you've asked some questions of the registry, basically, in the Magistrates Court or the County Court about what the current delay in that type of case is. There's always an element of guesswork, and most magistrates are quite pragmatic about it, and often they'll have a better idea than we will. So His Honour set out there that, and it's quoted at paragraph 7 of Justice Williams' judgment, it is clear from experience that the FSL, it's Forensic Science Laboratory, delay is at a minimum 6 to 9 months, in many cases longer. Committal mentioned to contested committal, 5 months, where there are a number of defendants, committal to trial in the vicinity of 12. So doing the maths, His Honour found it was over 2 years, and as the cases that Justice Williams sets out establish, that is of itself capable of giving rise to exceptional circumstances. And in many cases, given the current state of the list, in many cases you'll be able to generate evidence of a delay in that vicinity, and without anything more on the strength of this case, you can put that there's an exceptional circumstance. And ultimately, Her Honour found that His Honour was entitled to find precisely that. So that's why, or one of the reasons why, delay is so critical. First, it will commonly arise, and second, perhaps counterintuitively, an ordinary delay, even though it's very long, might give rise to an exceptional circumstance. Now, this is another way in which case law might be useful, because that is a pretty counterintuitive proposition. A delay of 2 years is relatively normal. Why then is it an exceptional circumstance? And you might encounter resistance from a magistrate to this proposition based on that simple and apparently logical observation. Well, again, case law provides your answer. Same paragraph from Cotsey's case, paragraph 33. His Honour said this: accordingly, whilst there is necessarily a level of pragmatism involved in the concept of delay, its operation cannot be limited by reference to what is currently regarded as normal for the prosecutorial process. So if the magistrate was tempted to reason that because this delay is not out of the ordinary, it's not an exceptional circumstance, that quote from Justice Couldry kills that off. They're not allowed to reason in that way. It's wrong in principle. And underlying the cases, it seems, and there are others, Justice Williams quotes from Justice Vincent, who said something to a very similar effect, is that the courts are probably trying to convey to Parliament in their own way their displeasure at the blowout in delays. It's not acceptable to have people on remand for 2 years before trial, and we'll continue to find that it's an exceptional circumstance and grant these people bail. And if you've got a difficulty with that, then resource the criminal justice system properly and they might remain in custody. That might be seen as something which underlies these cases. Now, returning to the theme of modes of reasoning from a magistrate, which might result in the refusal of bail being undermined by some principles from the cases, the other one that I think's very useful to do that is the recent case of Kyle McGee. Now, this is a rare example of where I've actually seen a magistrate who wanted to refuse someone bail, grant them bail, just because counsel cited this case. Kyle McGee was, I don't know if he was a graffiti artist, but in the words of Justice Forrest, he was a serial defacer of advertising in this state. He seemed to have a political commitment to defacing advertising. His priors weren't that impressive. He'd done it 6 times in 2 years, but he was up on another 3 charges, one of which was committed while on bail. He defaced in some way the advertising board on the tram stop outside the county court in William Street. Now, based on the fact that he, it seemed, had a political commitment to this kind of offending, he was highly likely to reoffend. But at that point, he'd been in custody on account of defacing that shelter for over 2 months. Now, it's evident from reading the judgment that His Honour found that offensive, and he granted him bail. And the reasons for doing so are useful to bear in mind. It's only a brief case, but if you've got a little bail folder, I'd strongly recommend adding it. There's a quote buried in there from Justice Fox in Burton and the Queen to this effect: "It is not normally a factor of any great weight adverse to the granting of bail that an accused person may possibly commit a crime while he is on bail. It should not be readily assumed that he might commit an offence or further offence. If he does, he will be dealt with by the criminal law. There are, however, situations in which the consequences of any crime he commits while on bail may be so serious and have such widespread effect that the possibility he may commit a crime while on bail is an important consideration." And His Honour, in the rest of the judgment, paraphrases similar principles. And I've set out right at the end of the paper, this is the last element of it, one way of interpreting the case, and that is this: then considering whether someone is an unacceptable risk of reoffending, you should consider a number of other factors, such as the seriousness of those kinds of offences, the degree of harm they might cause to the rest of the community, the fact that they will be dealt with by the criminal law. His Honour also talks about the arbitrariness of detaining someone based on a risk, and so that can be a useful factor to cite, and the fact that the sentence they might ultimately receive would be shorter than the period they've spent on remand, which is of obvious concern. Now, it would be in the prosecution's interests to distinguish this case on the basis that defacing advertising is clearly one of the less serious kinds of matters that can come before the court. And so the prosecution might confine McGee's case to its facts, and the prosecution would usually be able to point out or point to greater harm to the community, which would be caused by your client's reoffending. But on the other hand, there are cases where this will, well, similar damage would be done, and that sort of distinction couldn't be drawn. McGee's defacing of that advertising did $340 worth of damage, and obviously he was likely to do that sort of thing again. Now, you might have had cases of people who are addicted to drugs who smash windows in cars and steal the satellite navigation systems, and that's their modus operandi, and they do it consistently. Now, in each case, the damage might be in that vicinity. And yes, they're on drugs and they are likely to do it again, but if that's all they do, then a magistrate on the strength of McGee's case might find it very difficult to remand them in custody on the basis that that's what they might do, having regard to those principles. I know we've got at least one member of the audience from Sunshine. There's a relatively famous offender out that way by the name of Charlie Valla, who would consistently get drunk, dial 000, make fake complaints and abuse the police, and constantly find himself in custody. Now, he did it so many times that custody, it seemed, was the only option for him. But I'd suspect that in a case like his, invoking this decision in Kyle McGee might genuinely be his ticket out of custody. Because, as I say, the offending in McGee looks highly likely to have happened again. Now, before I put aside Cotsey again, there's another observation I want to make about that case. That was an exceptional circumstances case. It's a very helpful little compendium of the kind of circumstances which have been regarded as exceptional. And one of the useful things about it is that when you look at the kind of circumstances, they really aren't. So I suppose one way of putting it is that these cases tend to help you in establishing counterintuitive propositions. Someone who's a low flight risk and has obligations to his family, whose co-accused was granted bail, so far not much out of the ordinary. But those kind of considerations were enough to establish exceptional circumstances in Cotsey, and the decision was upheld by Justice Couldry. It's also useful for this reason. The case against him, you could say from the point of view of the defence, was exceptionally strong. So when it's put against you, there's a very strong Crown case. Citing Cotsey might take the sting out of that. He was found entering a hothouse on a property with a pair of orange-handled scissors. In the hothouses were a number of cannabis plants, the total weight of which was 1,479 kilograms. When they weighed the usable material, that was in excess of 350 kilos, worth between $1.5 and $2.5 million. He also had in his top pocket the business card of a hydroponic company. So it's worth, perhaps, when it's put against you that there's when it's put against you that there's a strong case against your client, you can say, well, there's a pretty strong case against Mr Coetzee, and point to the kind of circumstances which in his case amounted to exceptional, because you might be able to generate the same kind of circumstances in your case. And the other useful thing, I suppose, is it's a drugs case, and they're often the cases in which exceptional circumstances have to be argued at magistrates' court level. And I've put in the paper a list of some topics that I think are useful often to explore in the evidence on those cases. Just one thing I should expand upon from that list. I've put in there that it's often useful to cross-examine the informant. Usually the way the operations work is there's a period of surveillance, both physical and perhaps telephone intercept, up until the execution phase. At the arrest, often simultaneous search warrants executed at different properties, drugs are found. Usually the bulk of them, well, not necessarily the bulk, but the hard evidence of a quantity trafficked by your client might be connected to the premises. Whether they've been involved in trafficking for the rest of the time might only be established by transcription and analysis of the telephone intercept material. So one of the themes that's running through the paper in how to run those cases is query the extent to which the Crown case is at this point speculative and can only really be established based on further work. Always bear in mind that what puts you in a position of having to show exceptional circumstances is the quantity. So perhaps focus the magistrate's attention on that. It might be pretty clear that your client's a drug trafficker, but why is it that the Crown can say at this point that they trafficked in that amount? And that's where the Crown case is likely to be at its weakest. So clarify the basis on which the charge is put. Is it put that your client is trafficking because they're in possession of an amount deemed to be a trafficable quantity under the Act? If so, is the possession based on their occupation of this premises? And if you don't know the answers to these questions, I think usually it's not too disadvantageous just to ask them in an open-ended way of the informant in cross-examination to clarify the case. And if you don't do any good and it seems still to be a strong case, then move on. But it's worth having a go at it. Best to do it first outside court, if you can. And if the alleged link is to a premises and your occupation on it, find out who else was there. Whose name's on the lease? Who owns it? Who else was observed living there? Try and establish that these might be, well, if the premise is occupied by someone else, it really complicates the Crown case on that score. That's quite specific to drug cases, but in my experience they can be difficult to win because of the exceptional circumstances requirement. Now, we're getting on in time and we should have time for questions, so I might leave it there.
Thanks, Matt. Before you leave, can I ask you a question? When you talk about the fact that bail can't be used as a method of punishment in advance, does that mean that the strength of the Crown case logically can only apply to the risk of flight?
You stumped me there, Michael. I've never thought about that in those terms.
Do the authorities go, as I understand, the authorities really don't go as far as saying that. I mean, on your understanding, is that something that you're capable of arguing?
I think if you were pressed, you'd have to concede that there are other considerations, particularly the risk of reoffending. But I agree with you that logically the strength of the Crown case is perhaps most closely linked with the risk of flight, and if the prosecution want to establish the risk of reoffending, a strong Crown case alone really won't do it.
I mean, it appears, doesn't it, that the Bail Act itself contemplates that there is some element of punishment in advance, in the sense that the likelihood of reoffending is something that you can take into account. Now, even though Justice Forrest might have said, well, look, that's not something which you should give particularly great weight to, but nevertheless it seems to some extent to be a consideration, doesn't it?
Yes, and I think the manoeuvre that you'd recommend on behalf of the Crown, which would usually work given the relatively minor nature of the offending in McGee, is to point to greater harm to the community that would be caused by reoffending in a particular case, in a drug trafficking case. That would certainly be a powerful submission.
Now, are there any other bail questions?
Yes.
If you've got a client who's on remand for serious matters and has also been breached on his parole on the allegation of the offences that he denies, and he's also on remand for, and you go to committal and relatively successful in weakening the Crown case, and you then apply for bail, how do you address the issue of the breach of the parole, and to what extent is it appropriate for the magistrate to take that into account?
That's a good question. I recently had a client, I didn't ultimately do the application, but she was in precisely this situation and got into a residential rehabilitation facility with the Salvation Army. And the Crown were going to agree to bail if she had a bed at that facility, but she'd breached her parole. We made representations in advance to the parole board and said, would you parole her if she was granted bail? They said, we're not going to tell you. We'll deal with that if it comes up. So we had to sort of take a punt. Ultimately, that was done. She was granted bail despite the fact that she was still in custody on account of the time she owed the parole board, and then the parole board changed its mind and released her. But in answer to your specific question about whether the magistrate should take it into account, no, I don't think they should take into account what the parole board may or may not do. They really should, I think, just decide the bail application on its merits. And because they're prevented by the Sentencing Act in that context from taking into account what the parole board would do, I think instinctively most magistrates would agree. I can't cite any authority beyond that, but I don't think you'd have much difficulty convincing most magistrates that the question of bail is to be considered quite separately, because ultimately your client might well be taking a risk by being granted bail while they're serving parole time, because they are sacrificing possibly pre-sentence detention, because it'd be time served doubly warranted.
More an observation rather than a question. Ties in a number of points. You said a case I recently had was still conducting. The guy, young 21-year-old, was in custody down in Frankston for that stage 3 sets or 4 sets of obtaining probably by deception about, well, that stage about 100 plus charges, probably 200 grand minimum value. He'd been put in custody for breaching bail because he'd been alleged to have committed further offences of a similar nature whilst on bail not that long before for the first lot of charges. My initial reaction was it's nowhere near ready to run a show cause. Thankfully I had a client and a family that was very receptive, and I kept him in custody until the following Monday when I came before a good magistrate and he actually got bail on a show cause. And one of the factors there was delay, and then, as you say, you ask a sensible question of the informant. In this case, it was clear that it was going to take a lengthy time to prepare the various briefs, and there were potential other charges that hadn't even been investigated yet. I was able to get that out without being in any way harsh or tough cross-examination. I was able to get out of her easily in cross-examination. And it's one of the reasons, together with a number of what you call ordinary factors, counterintuitively, the factors combined got him bail and got him on the show cause and got him out. So just tying in, you have to be on your guard, don't get pressured into doing things that are going to run against your client's interests. It's better that they spend a few nights in jail than in custody, rather than, and when you do the application, it's going to have a much better chance of success.
Yeah, I agree. And if it's so helpful to have a client that's able to recognise that. Often the hard work's persuading the ones that can't. But I also agree with you about the informant and the prosecution. In my experience, both of them are 99 times out of 100 very reasonable in bail applications, and will make appropriate concessions and focus on a really legitimate concern in a particular case about why they're opposing bail, and will hear you out on that concern. So outside court, I've found generally negotiations are very amicable and productive, and should always be approached initially at least on that basis. And if you need to play hardball, the time to do that's in court, in cross-examination.
Thank you. Now I think we'll have to leave the bail questions there. Any questions in respect to committals? No. Thanks very much for your attendance. It's been a pleasure to be to have been involved in being able to do this presentation on behalf of Michael Green and the members of Green's List. When's the next of our breakfast? Today week. And what's that, Mark?
Criminal Procedure Act.
So we hope that we'll have the opportunity of seeing a number of you here again. Thank you.